Again, by the concept, they are confused. Very confused by concept. We cannot very all the emphasis on the system. It's not what we are getting. Now we have forgotten how why the local care is critical. And then they have traveled so much beyond the destination. They are supposed to travel up to they have traveled up to Chennai. They between Chennai then they are doing that. So I have narrated the draft letter. Because the economic situation of the solar but in the individual opinion of the scope, the power to make laws, so whether that meeting is critical or not, but the laws is the basic issue to be decided on this one. Whether the center has the power or the state has the power. So normally, if it happens, goes to the and we know that in case of a conflict between this one and this two, this one that he was given by the court without divergence. But when It's not that you're reading about the existence of the tree, the world, and everything. But I don't experience where about the book, everything was there. But therefore, that where this one is there. This actually not the biggest one, subject to and the foreclosures. That's why they're. But we have to break. So in the break is, what is this? You will see, is there.
Item number 8, mine. Just your lordship recollect, last time I said additional affidavit to be
You
filed.
taken
So
some
we
time.
have filed the additional affidavit. So when the matter reaches your lordship will just direct to bring that additional affidavit.
Okay, already filed.
Yes, yes, we have filed and we have served the
And
copy to the,
copy.
yes.
Just call for the file. Yes,
Deeply.
any mentioning.
May I please, Lordship?
Yes.
Lordship, I beg to assist the court. Item number 1. There's one order passed by this another court. So this matter may be, this is some other bench. Item number 1. Is it
Yes,
pertaining to
yes,
appeal?
that it could be,
All
no?
pending appeal.
Still,
Yes. They have filed one IA praying for that additional evidence again.
okay.
So the matter may be listed under some
Okay,
appropriate
please list
bench.
this matter before any other bench without me.
Lordship, I beg to mention item number 1.
Item 1, they have just mentioned. Motion.
Yeah, motion
Yes,
item number
yes.
1. I'm
Mention.
appearing on behalf of my senior.
So this court cannot take it up.
Yes,
So,
yes,
yeah.
yeah. I think
This,
you must remember.
Yes.
Yes. So kindly fix the matter on 12th June as per the convenience of my principal counsel. Because the principal counsel, they're all stationed at Gauhati.
No, we have said any other bench, so it will come up
Yes.
automatically. Yes. 12. It's okay.
It's okay.
12 then.
And your lordship may kindly reflect the principal's name in the cost list. Kindly direct the
What's
registry
the name?
because
Name
yeah, I'll give to
is
the names.
the name of the leading
Yes, yes.
counsel, Shri such and such, be reflected in the cost list.
AC Sharma, BC Talukdar, and Pranab Chakraborty. Yes.
There are some other matters also which this court cannot take up. I have noticed. I think,
Item 29 as well.
yes, this one also, item 29 also, before any other bench.
Did-
Then there was another one I had seen. Name. Yes,
29, we've taken note of it.
29.
Then oblige your lordship.
Lordship, I have item number 9 to 28.
9 to 28.
Yes, Lordship, I am yet to complete my counter affidavit. So 3 weeks may be granted in order to
3 weeks.
complete the
Petitioner.
counter affidavit.
I have no objection, Your Lordship, but however, Your Lordship, there is an order directing the states to file their affidavit on or before 14th of this month, which has not been complied with. So let this be the last opportunity.
How much time do you need?
3 weeks.
Instead of taking time again and
Yeah,
again?
Lordship, the
it-
PEC is communication. We are facing a lot of problem with the PEC. Unless we
Okay.
take, yeah, PEC.
Then you take 1 month's time and then make sure that it is filed.
Okay, Lordship.
Yes. Learned additional AG, M. Tim Song prays for 4 weeks' time to file the affidavit in opposition on behalf of the state respondents. Stop. Learned counsel for the petitioner, I. Im Chen, has stated that the state respondents have already taken many opportunities to file the affidavit in opposition, and therefore this may be the last chance. Stop. It is directed that the learned additional AG shall positively file the affidavit in opposition on the next date.
Your Lordship, again, for respondent number 9 in all of the cases, I have taken steps to register posts. But since they are not appearing, I may be allowed to take steps through Dusty.
Respondent number
9 in
Nine.
all the cases, yes.
It further is stated by the learned counsel for the petitioner that steps had been taken on respondent number 9 on several occasions, but the notice has returned unserved. Accordingly, he prays for permission to take steps for service on respondent number 9 by Dusty. Prayer is allowed. Petitioner shall take steps by Dusty on respondent number 9 and file the affidavit to that effect.
Much obliged.
One, two, and three.
Yes, Santiago appears for respondent number 1, 2, and 3.
I filed my affidavit.
And affidavit in opposition has already been filed.
Much obliged.
May I please, your lordship, I beg to mention here in item 35. On consensus prayer, pray that this matter be listed on 3rd of June.
3rd of June.
Yes, lordship.
List the matter on 3rd June 2025 on the prayer of the learned councils for the parties.
Interim may be extended, lordship.
And the interim passed earlier shall continue till the next date.
Similar prayer for 36, lordship. If this may be listed after 3 weeks.
After 3 weeks.
Yes, lordship.
36, list the matter after 3 weeks on the prayer of the learned counsel for the petitioner. Learned
Obliged.
government advocate is present.
Obliged.
Ma'am, this one,
Yes,
Lord, I beg to mention item number 34.
34.
Lord, I'm mentioning on behalf of the senior counsel, Gauhati. As the senior is having some personal difficulties, so I beg that if this matter could be adjourned for 3 weeks, ma'am.
3 weeks.
Yes, ma'am.
And where is the respondent?
Yes, my lord, he's in the other court.
Learned counsel appearing on instructions from Mr. Gauhati, CGC, prays for 3 weeks' time.
Yes, my lord.
As Mr. Gauhati has some personal difficulties today. So accordingly, list the matter after 3 weeks.
Obliged, madam.
My pleasure, Lordship. Lordship, I beg to mention item number 31 and 32
Yes,
on behalf of Espere. Can you list this matter after 1 week?
on behalf of
Espere,
Mary.
Lordship.
No objection.
After
1 week.
1 week. List the matter after 1 week on the prayer of Mrs. Mary, learned government advocate. Learned counsel for the petitioner has no objection. Yes.
I oblige.
Please, your lordship. I
Yes.
beg to mention item number 7.
7.
Kindly grant 3 weeks time to file affidavit in reply. I've taken the
Affidavit in reply.
yes, I've taken the consent of the opposite party.
Learned counsel for the petitioner prays for 1 week.
3 weeks.
3
time.
weeks time to file an affidavit in reply to the affidavit in opposition of the respondents. Praise allowed, list the matter after 3 weeks.
There is an interim.
The interim passed earlier shall continue till the next date.
Much obliged.
Yes.
My please, your lordship.
Yes.
Lordship, this interlocutory application, number 70 of 2025. As per the last order 9 for 2025 for implement of the DGP, Director General of Police State Cybercrime, as respondent number 2.
Learned counsel for the petitioner, MS such and such is present. This court by order dated 9/4/2025 had allowed the petitioner to file an application for impletement of necessary parties on or before 9/5/2025. Stop. Hence, the present application has been filed. Praying for impleading the Director General of Police, State Cybercrime, CID crime, 7th floor, block 2, you check out later, okay, from the application. Karm Yogi Bhavan, Sector 10A, Gandhinagar, Gujarat, as respondent number 2. Stop. Prayer is allowed. The petitioner is allowed to make the necessary rectification in the cause title. Yes, I dispose.
Item number 3
My please, your lordship.
Yes.
Lordship, I have received the hard copy filed by the additional affidavit of the copy filed by the state only today, lordship. So if I may be given another 2 weeks' time, your lordship.
Additional affidavit.
Yes, your reply to that, your
Oh,
lordship.
you want to file a reply?
Yes, your lordship.
Learned counsel for the petitioner, Ms. Such and such, states that she has received a copy of the additional affidavit filed by the state respondents only today and prays for some time to file an affidavit in reply to the same. Prayer is allowed. List the matter
If it can come up on 5th of June, your lordship.
on 5th June 2025.
Much obliged.
Learned government advocate is present.
Item number 6.
My pleasure, Lordship. Lordship, at the present case, Lordship, the petitioner is seeking for appointment on land ownership basis.
All respondents are appearing.
Lordship.
Respondent 6 also. Okay. Yes.
Shall I continue, Lordship?
Okay. Yes.
Lordship, as I've stated earlier, now the petitioner is before this honorable court seeking for a direction for appointment on land ownership basis.
Mm.
And then here there are only 2 issues involved in this case, Lordship.
Okay.
Firstly, whether appointment has been given to the landowners legally or not. And then secondly, the appointment of private respondent number 6 was done as per the law or not. Those are the only issues in this case. So here the petitioner, Lordship,
Have you annexed that OM, that land ownership?
Lordship, yes. There are various office memorandums, policies where I've enclosed in my petition also, and even the counter affidavit also they have state government have also enclosed in your affidavit.
So now we have to go according to that, like there is a cutoff date.
Lordship,
Yes. Anyway, yes. What is your case?
yes, Lordship.
Yes.
Here, in the year 1959, your Lordship, for the establishment of school at Young Yamson village, an oral agreement was made between the landowners in the government. And then accordingly, the land was acquired in the year 1959 by the department, that is the school education department. And then till date, the school has been functioning as GS Government High School Yongyamsen at Mugukchong Nakalan. So, and those this due to lack of legal awareness, and then when such oral agreements are being met, in order to solve all these issues, the state government have come with a policy where at annexure 1 page 17, the type copy is at page 18, where the Undersecretary School Education is written a letter to the Director of School Education conveying the policy decision for appointment under school education. The relevant part that is dated Kohima the 5th August 1991 to the Director of School Education, Nakalang Kohima, subject recruitment of candidates for various posts under school education. Sir, I am directed to refer to your letter number such and such dated 26/7/1991 on the above noted subject and to convey the decision of the government for your necessary action. The relevant part is serial number 5. That is for grade post, that means grade 4 post. Here it lays down that direct appointment should be made by the appointing authorities from among the landowners whose ownership of land is certified by the village education committee and local administrative officers. Here, the petitioner is solely covered by these provisions, your lordship. Why? Because and then here, but number 5, it clearly says direct appointment, which means to say that it's a regular appointment or a permanent appointment. So regular appointment should be made by the appointing authorities. That was the policy taken and then was written to the Director of School Education so as to function under the Department of School Education. So the petitioner, being the landowner or owner of the government middle school at Yongyamsen, where the high school stands. So on learning about one vacancy created by Shiril Let Shulumern Carpentry Helper, the petitioner, annexure 3 page 20. This was the vacancy post created by the one Shiri Shulumern Carpenter. Annexure 3, dated deletion order dated Mugokchong the 25th January 2019. On his sudden demise, late Shulumern Carpenter Helper at Yongyamsen is hereby released from the establishment with effect from 6 January 2019. This was the vacancy created on that particular school. So on the basis of that, the petitioner had submitted an application to the Principal Director of School Education, that is page 19. Annexure 2, yes. It was written to the Principal Director on the subject application for appointment to the post of Carpenter Helper against Shirley Shulumern, expert of Government High School Yongyamsen. And then the first paragraph, with reference to the subject cited above, I beg to state I'm an educated and employed youth in the rightful landowner for claiming the post which is lying vacant on account of expiry of late Shulumern on 5th January 2019. This was the application claiming appointment of ownership before the government. And then accordingly at page 21, the petitioner's application was forwarded. It was forwarded by the district education officer Mugokchong to the Director of School Education by forwarding the petitioner's application and forwarding all the necessary details of the petitioner. Then the council, village council, that is the next CM on 12/2/2019 at annexure 9 page 26. Which was signed by the chairman, GB, and secretary of the village council Nexium. It also written a recommendation letter where it states that in support to the 1959 agreement between the landowners of the GSS Yongyamsen building, the building of the main GS belongs to Shiri Yashimern and the RMSA building falls and Shirilet Imli Onanslin. Here I'm only on the GS where belongs to Shiri Yashimern line. Therefore, the village council Nexium is recommend that Shiri Yashimern is the right to pursue for the 4th grade post created in the government has Yongyamsen at the landowner. as landowner. This was also the recommendation letter written by the village council. So after submitting the first application to the authority, to the school education department, no action was being taken. So the petitioner again submitted another representation, that is on 11 June 2019, and next then page 27. And next then page 27 to the Director of School Education, subject representation. And then yes, this was the second representation submitted to the department. Now, after submitting the representation, while waiting for the petitioner's name to be approved for appointment of the grade for post, now the petitioner came to know that it annexure 11 page 28, where some list of applicants who were approved for appointment on grade for post, that is annexure 11 page 28, written by the Undersecretary to the Government of Nagaland School Education, do the Principal Director School Education on 7th July 2022, subject approval for appointment to grade for post under compassionate scheme. And then I'm directed to refer to your letter such and such, 27 September 2019, the subject cited above and convey the approval of the government for regular appointment of the following 13 applicants under compassionate scheme. So here on the next page, these are the applicants, serial number 9. This is the private respondent number 6, where his name was also recommended for appointment, Shri Mayang Tupal Longhammer, carpenter, to the post of carpentry helper. And then it is to be noted that the post created by Shri Shuluman, Mayang Tupa is the son of Shri Shuluman. So they were seeking appointment on compassionate, yes. That was the approval letter written by the Undersecretary, which is under challenge in this main petition. So after issuing the appointment order, approval order, now the Principal Directorate issued appointment order to the private respondent number 6, that is annexure 12 page 30. Annexure 12 page 30. Government of Nagaland Director of School Education, dated the 1st August 2022. The date is mentioned on the last line. 1st August 2022 order. On the basis of approval of the government, conveyed white letter dated 7/7/2022. The following applicant is hereby appointed as carpentry helper on compassionate ground at GSS Young Yamson under the establishment of DEO Mukokchong and the payable such and such. Number 1, Shri Mayang Tupa Longomber. And then on the right side.
But
Why-
this was a different ground, compassionate ground. You are praying on land ownership basis.
Yes, Lordship. Here on the vacancy created by Lead Shiluman, that is the carpentry helper post, I was seeking that post on the basis of land ownership. But then now, Shri Mayang Tupa being the son of Shri Shiluman, who created the post, now they've also before.
Considered him for compassionate.
Yes, they have given the appointment on compassionate basis, where I'm aggrieved by his appointment order. So after passing the appointment order against respondent number 6 illegally by the department, now again I being aggrieved, I submitted an ultimatum, which is it in extra 13 page 31 to the Principal Director of School Education. I'll just read the relevant part, that is number 1.
Yes.
That in the year 1959, an agreement was made between the landowners of the GSS Young Yamson building Mokokchong Nagaland and the government, where the land was donated freely to the government through the stewardship of the Mokong Sangar Putu Menden in October 1959, where the present GSS Young Yamson building stands, and for which agreement was executed among the parties. And then the last second paragraph. Take notice that the instant notice ultimatum may be taken up from your end promptly, urgently, and seriously and cancel the office appointment order dated such and such of Shri Mayang Tupa and appoint Shri Chongshinok Longkamar, that is the petitioner, on the basis of landowner within a period of 15 days. And then take further notice that any failure to do, the landowner will not compromise, and we have decided to take our own course of action from this end to the extent of directing your department to vacate the land on which the present GSH stands. So here the petitioner humbly states that oral agreement was made between the parties, between the government state respondents and the petitioners. And then after that also, the school education has also issued a policy decision conveying that grade 4 post appointment should be given, that also on regular basis. But then, and then while pursuing for the said vacant post, now the state respondents have appointed private respondent number 6 illegally. The petitioner is saying that the private respondent number 6, he is not entitled for compassionate appointment, Your Lordship. But then for appointment on land ownership, compassionate appointment, there are certain criteria and conditions laid down, which I'll show you as my submission. At my submission. So after the appointment of the private respondent number 6, the petitioner through a council filed an RDI before the Director of School Education, which is it annexure 15, page 33. Page 33. Since the private respondent was appointed on compassionate basis, now RDI was filed, and then the reply was given on November 2022 to Shri such and such. Subject reply to RDI query. On the subject cited above, I am furnishing here with the information as sought by you pertaining to the employee or applicants appointed on compassionate ground with effect from 2015 till date, as given in table below. The relevant is the serial number 2 on that particular page. I've written here, detailed list of applicants to be considered for appointment on compassionate ground. Provide us with their date of application and the date of death of the employees to which posts are seeking for. So from page 34 till page 42, Your Lordship.
This is the list.
This is the waiting list maintained by the department. Yes. Here in this list, the name of the private respondent is not here. Leaving all those 135 applicants, the private respondent number 6 was given appointment. Even though he is eligible for compassionate appointment, there are certain rules and provisions laid down in the compassionate scheme. But then after leaving all those 135 employees, the department is given illegal appointment to the private respondent number 6 illegally. That is one ground, Your Lordship. Nowhere in this list the names of these private respondent number 6 is listed here.
But he was already appointed on August 2022.
Yes, Lordship.
And this waiting list is November 2022. So he will not figure in the list.
Yes, for that I'll show you. At page 34, serial number 1. On the 1, 2, 3, on the 5th line, date of expiry of that particular employee.
Column.
Yes,
Column.
that was on 9/6/2014. Here, Mr. Shillerman, he died on 2019. And then this particular person, expiry is 2014. Since 2014, they are waiting for the appointment. And then now the person who died on 2019, automatically they have given the appointment without following the conditions laid down under the compassionate scheme. And then date of receipt of application also on 2014. These all were submitted prior to the private respondent number 6 application. That is one.
But how can you claim a particular post as a matter of right? Because your only claim is that you can be considered as a landowner
Yes, Your Lordship.
as per the notification of 5th March 2018.
Yes. First ground is as Lordship has
Yes.
pointed
Yes.
out. First, the office leader, which I've shown it in extra one. Grade for post direct appointment should be given to the land ownership. Secondly, there is also one office memorandum which I've included in my writ petition, that is annexure 16, batch 43.
Hmm.
That is office issued by the BNER on 3rd March 2022, filling up of group T posts in the department, corrigendum issued such and such. Number two, following difficulties expressed by various departments on account of the fact that in many cases, group T posts such as jokators, malis, and peons are filled by landowners or on compassionate ground, and locally the district, subdivision, or village level. The matter was considered by the cabinet in its meeting held on 9 February 2022 and 22nd February 2022. In order to remove such difficulties, it is hereby directed that the condition of advertisement is dispensed with wherever such difficulties are faced by department, as long as a fair and transparent eligibility criteria and process is followed, and all such cases, approval of the government is obtained. This is the one ground, this is the ground why, because in most of the cases, lands are being donated by the landowners to before the government authority, and then appointment is being given to the land ownership on regular basis. And then till date, no regular appointment has been given by the respondent authority, and for which the petitioner is before this honorable court seeking for a direction to comply as per the criteria laid down in the office memorandum. This is one thing. And then now, Lordship, now the state respondents.
Your prayer, just say your prayer.
Yes, Lord.
Your prayer is only to quash and set aside the approval of the private respondent and then his appointment order.
Yes, Lordship. We are aggrieved by the appointment of the private respondent number 6, because appointment on land ownership was not given to the petitioner, to the landowners, but then instead illegal
No,
appointment was
but
made.
how can you say that particular post should be given to a compassion for land ownership?
For that, I'll prove to you, Your Lordship. But because there are also various documents which has been annexed in the petition as well as in the counter
Because it's
affidavit.
up to the authorities. It can be any grade 4 post.
Yes, Lordship.
Yes.
And then since not even a single grade 4 place is being given to the landowners, that's why the petitioner is approaching this.
today.
Yes, Lordship. Because appointment on ownership or compassionate, it should be regular appointment. Like the compassionate, it should be regular appointment. But until date, no one is being given appointment on regular basis.
Okay, yes, Governor Advocate. I think that's all.
Lordship, here,
Sure, yeah,
I have some lines.
yes, okay.
Now in the counter affidavit, Your Lordship,
Mm.
the state respondents, they enclosed one notification, which was filed on 2/7/2024. Affidavit in the position of respondent 1 to 5.
Yes.
There, they have one enclosed one notification. The type copy is at page 9.
Yes, yes, this is the one I was talking about.
Yes, yes. They are taking the stance on
Latest one.
3B and 3C.
Yes.
3B, 3C.
3B,
Merit 3B, yes.
3B.
3B and 3C.
Mm.
3B, it says, let's down that. If there is any claim for providing employment as a result of rural agreement, like the petitioner's condition, the department council shall refer the matter to the deputy commissioner of the district concerned, who shall examine such claim carefully, including whether any employment or any other facility, including contract or supply order, has been given in the past. Written statements from the witnesses, that is government officials of the concerned department, and the district administration and the village functionaries present at the time of such oral agreement should be taken by the DC. The recommendation of the DC should be referred with relevant documents to the Department of Land Revenue for advice in such cases by the department concerned. That was one ground. And then on 3C, It is also clarified that it is not the policy of the government to provide employment to the landowner and perpetuity. These are the two grounds taken by the state respondents in this petition. So, since only oral agreement was made between the respondent authorities and the petitioners, now, on the basis of that, the AKNDA filed one additional affidavit, Your Lordship. One additional affidavit enclosing later dated 13/9/2024.
Affidavit is dated.
In my affidavit, no date has been mentioned.
Additional affidavit on filed on
On
14 November.
14/11, yes,
14
Lordship.
November.
Here, I'll take you directly to page 6 of the annexure. So
Yes.
this was written on the basis of 3P, where we read those notification. It was written by the subdivisional officer to the deputy commissioner on 10 October 2023, subject verification of genuine land owner at GHS Yongyamson. Sir, with reference to letter such and such dated the 30th August 2023 on the subject cited above, I have the honor to submit here with the verification report of Dupashis and regard to GSS Yongyamson, which is enclosed and self-explanatory. So as per the notification dated 5th March 2018, verification was done, and then the report, they have enclosed a type copy at page 8. This is the spot verification report. Merit, Your Lordship. Government of Nagaland, Office of the Custom Record of the Pashis, Changdongya, Nagaland, dated the 9th October 2024. To the subdivisional officer Changdongya, subject spot verification at GS Yongyamson. In regards to the subject cited above, and as per your direction on the letter such and such, the undersigned along dated 5th October 2023, the undersigned along with 2 DBs of custom record Changdongya went for spot verification at GS Yongyamson on 9/10/2023, and verified that the genuine landowners of the land in which the school is located is Yashimern and Noklan Nixi. Yashimern is the petitioner's father. It is pertinent to note that the petitioner Shri Chongshinok is the son of Shri Yashimern. However, as per the verification, the family of Mr. Yashimern have not availed any facilities from the government, which means to see that no appointment has been given.
This verification was done after the filing of the writ petition or before?
Yes,
Uh,
well, the
so-
writ petition
so
was pending.
As per this notification
Yes.
of 5th March 2018.
Yes,
Uh,
but again, after that, there's another verification.
I'll,
So-
oh,
yes, so well, pending as the Lordship has pointed out, the present petition, this was, verification was done, and then this was the result submitted by through the affidavit. Now, after that, again, the state response, they have filed one additional affidavit on 19/3/2025.
yes.
For that, may I take you to page 2 of para 3, page 2 of the affidavit, additional affidavit para 3. This para is very important, Your Lordship, para 3, that subsequently, as the letter dated 13/9/2024, that is the verification report, issued by the Director of School Education, is silent on the appointment of any members from the family of the petitioner to government service on land ownership basis. This is one ground, and then bypassing an order dated 22/11/2024, this honorable court has directed the state respondents to ascertain as to whether any appointment in government service has been given to the family members of the petitioner. Here, first line says, the Department of School Education is silent on the appointment of any member from the family of the petitioner on land ownership basis. Secondly, whether any family members of the petitioner has been given appointment or not. First one is on land ownership, whether appointment has been given. There are two aspects here. appointment on land ownership, and then the other
And
one
whether
appointment.
anyone has been given.
Yes, any appointment is being given or not. So after that, they've enclosed annexure showing that annexure H page 7.
Yes.
This was written by this Undersecretary School Education to the Council for the State. Subject WBC such and such. Sir, in compliance to this direction of the Honorable Gauhati High Court Kohima Bench, order dated 22/11/2024, on the subject studied above, I am directed to furnish here with the details of Shri Maung Tushi, Choketar at Government High School Young Imson compound. Further, it is submitted that Shri Maung Tushi is the biological brother of Shri Yashiman, that is the petitioner's father. And then on the
That
next
means
page,
your brother is already appointed.
yes, the petitioner's brother. They are saying that the petitioner's younger brother, biological brother, Shri Maung Tushi, he's been given appointment. He is working as chokitar. Yes, petitioner's uncle. And then on the next page, the type copy page 9. Here they have given the details of Shri Maung Tushi to the principal director. Details of Maung Tushi. On the subject studied above, I have the honor to submit here with the details of Shri Maung Tushi, biological brother of Yashiman, resident of Young Imson compound, name Maung Tushi, father's name Tamsil Tuba, designation chokitar, date of appointment 2002, and place of posting is under GSH Young Imson compound. And then on the next page also, verification report. This was given by the head to Pashi Changdongya to the STO Changdongya Nakalan, verification report on genuine land ownership. In attendance with the council chairman of Nexium, staff members of GSH Yongyamson and the land owners of the site, it has come to light that Mr. Mirin Sangba and Mr. Maung Tushi are currently working as fourth grade employees from the site of landowners, Mr. T. Yashiman and Mr. Arnakshi respectively. So here in this line, Mr. Yashiman and Maung Tushi is relevant in my case. Therefore, with this evidence, I hereby verify that Mr. Yashiman is a bona fide member, one of the genuine landowners of GSS Yongyamson located at Nexium. This was the verification report. So now it present, Lordship.
So are you denying all this?
Lordship, yes. I've filed an additional affidavit in reply to that. So, Lordship, here, as I've shown to you, Lordship, at paragraph 3, appointment on land ownership, number 1. Number 2 is whether any family members has been given appointment or not. There were two aspects. Now I filed one additional affidavit.
There are two additional affidavits. One is affidavit in reply.
Yes, one is additional affidavit.
Filed on 7/5.
Lordship.
Yes.
Page 3, paragraph 2. Mary, Lordship, for easy reference, I'll just read the paragraphs from the page 3. That in the additional affidavit filed by the state respondents number 1 to 5, the respondents have stated in paragraph 4 that Shri Maung Tushi is the biological brother of Shri Yashiman, father of the petitioner. And also by office letter dated 28/11/2024, annexure 1 to the additional affidavit of respondent 1 to 5, written by the head Dupashi Customer Court Chandongya, had stated that Mr. Mirin Sungba and Mr. Maung Tushi are currently working as fourth grade employees from the side of landowners. Mr. T. Yashiman and Mr. Arnakshi Longkomer and further verified that Mr. Yashiman is a bona fide member and one of the genuine landowners of GSH Yongyamson located in Nexium. It is hereby stated that Mr. Maung Tushi is the biological brother of Yashiman, petitioner's father, and employed as Chokitar at GMS Yongyamson. The petitioner further states that Mr. Maung Tushi was not appointed on land ownership basis and not as per the office letter dated 5/8/1991. That is the policy written by the school education to the writ petition, but was appointed on ad hoc basis by office order dated 25/2002, which clearly indicates that the appointment is purely on ad hoc basis and terminable without any prior notice. and the seat appointment without do not confer any right to claim for regularization without routing through interview board. Subsequently, by office order dated 2010, Mr. Mong Toshi's service was regularized on the recommendation of TPC. So at page 6 and 7, page 6 is the original copy, but since it's not visible, I've made a type copy. Page 7, annexure 17. Now the state respondents are claiming that appointment is being given on ownership. But then here in the appointment order, Lordship, dated Kohima 20 May 2002, Mr. Shirimang Doshi is hereby appointed on ad hoc basis as Chokiter at Government Middle School, Yamsen. And then on the second paragraph, the appointment is purely on ad hoc basis and terminable without any prior notice. That's one thing again. And on the last paragraph, the ad hoc appointment order do not confer any right to claim for regularization without routing through interview board. So, yes, I'm not saying that Mr. Mong Tushi is the uncle of the petitioner.
They're all landowners.
Yes, landowner.
Yes.
But then for appointment of land ownership, Lordship.
No, earlier they used to appoint like this. In all the departments, they used to appoint like this. Only after the coming of this 5th March 2018, now court are giving direction to consider as per this and then to appoint directly.
Lordship, yes. If
But
you're,
this is landowner. They are all landowners.
yes,
So
you're
how
landowner.
many landowners can be appointed?
But then landowners appointment are given regular appointments. Same like commissioner appointment. Commissioner appointment are also given regular appointments only.
Now he has been regularized.
Yes, it's been regularized, but it was done through interview only. Why? Because land ownership should be direct. And then whereas in 1981, which I've shown in extra one, it clearly states that direct appointment should be given. And then the state respondents in their affidavit says that the Department of School Education is silent on land ownership appointment because no one was given appointment on land ownership legally. That's why they are silent. And then on the other part, Mr. Mong Tushi, yes, they have given appointment from my landlord. They are members of the landowners, but then it was done on ad hoc basis and his service was regularized only through interview, where DBC minus is very clear. So the state respondents cannot see that land ownership appointment has been given, Lordship. And then even in this verification report, the Tubashi is clearly said that is state the petitioners, the landowners, they have not availed any benefits. And also on this verification report also, they have clearly stated that Shiri Yashiman is a bona fide member and one of the genuine landowners of GSH Yongimson located at Nakshium. And then batch then of my additional affidavit, that is the TPC recommendation for declaration of the particular person. On the recommendation of the TPC meeting held on 1/9/2010, the ad hoc services of the following staffs were regularized, and at page 11, my name is its serial number 11. And then here also nowhere in the documents mentioned that I was appointed on land ownership or whatsoever. They've just shown me appointed on ad hoc basis, ad hoc staffs, and then I was regularized through DPC meeting minutes. And lastly, for the private respondent number 6, Lordship, and your affidavit, your counter affidavit,
Respondent number 6. Yes.
Here, the only stand is that Brevis Bond number 6 was appointed on compassionate ground.
Compassionate ground.
But then here, may I take you to their own annexure F page 18. The last annex, page 18.
Mm.
This is the scheme office memorandum issued by the PNER for appointment on compassionate ground. So for appointing on compassionate basis, this is to be followed. PNER dated 17 September 2015, subject revised compassionate appointment scheme for state government employees who die in harness. I'll just take you to the 11 part, paragraph 7, page 19. Applicants under this scheme should be eligible and qualified for the post in all respects under the provisions of the relevant recruitment rules. No relaxation and eligibility will be made in any circumstance except to the extent provided under this scheme. Date of joining by a person appointed under this scheme shall be treated as the date of his or her regular appointment. All departments shall maintain a waiting list in chronological order for compassionate appointment. An applicant will be given the waiting list number on receipt of the application if there are no regular posts available. This is the provisions where I enclosed in my petition also the chronological order. The petitioner here states that respondent 6 is not denying that respondent 6 is not eligible for compassionate appointment. Yes, he is eligible for compassionate appointment, but for appointment on compassionate ground, there are certain criteria and conditions laid down under this scheme. And then his appointment was done without following all this procedure. There are more than 135 applicants waiting in chronologically, but then leaving behind all those, respondent number 6 was appointed illegally, so it is to be questioned set aside. His appointment should be given only when his turn comes. That is one ground. And then secondly, as I've said it earlier, no land ownership appointment has been given till date, because land ownership appointment scheme which I've annexed in the next year, direct appointment, it clearly says regular appointment. And then the other relatives of the petitioner, he was appointed on total basis, so that's not relevant in this issue. And then thirdly, verification report clearly says that I'm the genuine landowner, and then till date, my appointment has not been given. So appointment of respondent number 6 should be passed, and then direction will be given to the three respondents to appoint me on land ownership basis. That is my only prayer.
That prayer is not there in your petition. You have only prayed for quashing the approval order of the private respondent and for quashing the appointment order of the private respondent. That's all.
Lordship, in my application which I've annexed in the petition also.
Court cannot go beyond your prayer.
No, Lordship, in my
And plus, what right do you have to challenge the respondent's appointment, which is on compassionate ground? You cannot claim a right to a certain post.
Lordship,
The government can give you any grade for post, okay,
Lordship,
as landowner. But you
yes,
cannot claim that a particular post should be given to you.
you're right, Lordship. But then on that ground, till date,
And plus, his ground of appointment was different ground. On
on
compassionate
compassionate,
ground. You're
yes, but
claiming
it
on
was
that-
done illegally, Lordship.
But do you have the locals to challenge?
Yes, Lordship, since,
You are not compassionate appointment.
No, no, no.
You're
But
not
that
claiming
post
on
was not-
compassionate appointment.
that post was for general appointment, what
Yes.
compassionate and landowner,
Anyway, let's see what the government has to say. Yes.
Lordship.
May I please, my lady? The lady has rightly pointed out, the petitioner has to establish his locus standi. Now he is coming on the basis of land ownership weapon, but as my lord has already, my lady has already observed that the prayer is for question of the appointment of the private respondent on compassionate ground.
Mm.
Now my lady is already well aware, but just to refresh now she has to establish that he is on the waiting list as a compassionate candidate,
Mm.
which he is not. So he has no locus standi on that. And secondly, my learned friend has already pointed out that as regarding notification regarding the appointment of the appointment on the basis of land ownership,
Mm.
notification dated 5/3/2018. My affidavit in opposition. page 9, type to page 9.
1 minute. There are so many pleading.
Yes, dated 2/7/24. Dated 2/7/24.
Yes.
Yes, and then before jump into that, now none of those candidates who are in the waiting list in the compassionate appointment for the compassionate are not aggrieved by this order. Appointing the private responder, yes. Now, may I take my lady back to this notification?
This notification.
Yes. Last paragraph, 3C. 3C. It is married. It is also clarified that this is not the policy of the government to provide employment to the landowner in perpetuity. The employment of landowner, if permitted by a verifiable and valid agreement, is limited to the person first appointed as landowner in the government service and does not entitle his descendants for further employment on his retirement from service. So this is very clear. Now, the last additional affidavit, my last additional. Now, after this, since the status of the land ownership was not verified, then that first verification, then my learned official pointed out that
Yes, yes.
question of employment was asked to be verified again. And the last verification says that 2 persons from the land on the site were already appointed. Yes. And one of them is the biological brother of the landowner, who is the uncle of the presented petitioner. So in that view of the matter, to cut it short, the right available under this provision has already been exhausted. By the family of the or by the land or by the landowners, as far as this school is concerned, government high school, this government high school.
Yes. Young Wilson.
Yes. In a very similar case, the division bench of this honorable court has upheld the judgment passed by the single bench, where appointment was also made against compassionate ground, as well as the petitioner came on land ownership basis, and the same law was laid down by this. WPC 5/2016. May I take my lady to the relevant portion? Page 5, paragraph 5. I've underlined. Yeah. May I read? Just because the land was donated by his family and the family of the respondent number 4, that here are also 2 families donated land, it does not mean that they would be entitled to appointment to any grade 4 post for indefinite period of time and number. Appointment can be given only to the limited number of posts and not at all times. And last paragraph and the last sentence. But we make it clear that there should not be no more appointment in the office of the ESC Chetaba on the basis of land ownership henceforth in view of the new scheme notified by the state government 5/3/2028. So this is already a settled matter, my lady. So in view of this, I'm sorry to say that the petition has to be dismissed.
Yes.
May I please, my lord? My lord, here the petition is challenging on two grounds, my lord. One, that the state respondent has not followed any procedure and the appointment is illegal. And the second is that I'm not a landowner. Your
No,
lordship,
that
if
the court has already seen. Yours is the criteria of compassionate
compassionate
appointment.
appointment.
He's claiming on land ownership.
And yes, lordship, and lordship, if your lordship may take my counter affidavit filed on 11/5/2023,
Yes.
paragraph 4. There's an allegation that I have been appointed without following the procedure of law. If I may read, my lord, your lordship,
Page.
page 2, paragraph 4.
Okay.
Lordship has got it. Page 4A, that by notification such and such, dated such and such, issued by government of such and such, the governor of Nagaland is pleased to notify the policy with regard to the appointment to grade 4 post under the government of Nagaland on land ownership basis. That is a notification, your lordship. I will not trouble your lordship. Number B, that is page number 5. That is page number 3 and 4 is the quoted
Yes.
B. As per the said notification dated 5/3/2018, to claim appointment on the basis of land ownership, the petitioner first has to satisfy this honorable court that the landowner / petitioner was never given employment or supply order in the past. C. Except for stating that an oral agreement between the landowner and the government, the land in question was acquired in the year 1959 for the establishment of school at such and such. The petitioner is completely silent as to whether in the last 63 years, any employment or any other facility, including contract or supply order, has been given in the past to the petitioners. Next page, your lordship, page 6. Paragraph 8. May I read, your lordship?
Yes.
A. The deponent's father, late Shilumran, while serving as carpentry helper at Government High School, Yong Yimson, died in harness on such and such. Accordingly, by order such and such issued by the district education officer, he was released from the establishment. B. That the deponent's father was the sole bread earner and died leaving behind deponent's mother and 6 children. I am the eldest. A certificate to that effect is also being issued by the Yong Yimson Village Council. C. The deponent, being the eldest son of the Shilumran, has applied for appointment on compassionate ground against the vacancy caused due to the death of his late father. Accordingly, the such and such, dated such and such, forwarded the application of the deponent to the director, Nagaland, Kohima, lordship. D. The day after, on the basis of the approval of the government, the principal director of school education, such and such, has issued such and such, appointing the deponent on carpentry helper at GHS Yong Yimson on compassionate ground. So, my lord, every procedure has been followed by the government, and I was duly appointed by the competent authority. I will not trouble your lordship to my appointment order. Lordship has already seen it. It is categorically stated that I was appointed on compassionate ground. And my main ground, as your lordship has pointed out, that the petitioner has no locus to challenge my appointment, which was done on compassionate. Neither the petitioner is seeking appointment on compassionate ground. And your lordship, the petitioner has stated that I was not in the waiting list. Your lordship has also rightly pointed out that I was already appointed in the month of August. And the reply to the RTI was given in the month of November. And in the waiting list also, there's specifically, there's a column for post applied for. All the waiting lists, people who are in the list have been applied for that specific post to the specific area. And when I'm already appointed, there's no question that my name was not listed in the waiting list. May I take your lordship to my affidavit, page number 18. Petitioner has taken to your
Page
your
18,
lordship
that scheme.
scheme, yes, your
Yes.
lordship. In Roman number 2B,
Yes.
son, I am the son. So I'm wholly covered by this scheme. And I was appointed under this scheme. So the petitioner cannot say that I was appointed illegally, your lordship, and without following any procedure of law. Therefore, your lordship, in my respectful submission, the allegation that the respondent authority had illegally appointed the respondent's six on compassionate ground is baseless, your lordship. And the state has already filed an additional affidavit. The
Yes.
lordship, what has happened is, during the writ petition was pending, writ petitioner has brought a letter saying that the landowners have not availed any facility. So lordship, I made an objection that any facility and any employment are different thing, which is categorically stated in the notification. My affidavit, page number 13, your lordship.
Your affidavit in opposition.
Yes, the scheme 5/3/2018 scheme, page number 13.
The facility can mean contract works, etc.
Yes,
Or
should be that any employment or other facility, including contract. So the petitioner say that they have not availed any facility. So I made an objection, and the court has directed the government council to verify whether they have availed any employment. So again, that how the verification report.
Verification.
Yes. And in that, it has been clearly stated that the maternal uncle of the petitioner has been appointed, your lordship. Your lordship, lordship, I'm allowed to place some. 2022-12 SEC. That is regard to compassionate appointment, your lordship, the principal. Para 28. 3-4 lines. Lordship has got it. 28. It is well settled that the compassionate appointment is an exception to the general rule of public employment through open selection in conformity with Article 14 and 16 of the Constitution. And the object of granting compassionate appointment is to enable the family to tide over certain crisis and to grant relief of the family against financial destitution who have lost their breadwinner, your lordship. That much, your lordship. So my father died in harness, your lordship. And being the eldest son and being covered by the OM scheme for compassionate appointment, being the son, I have applied and I was appointed on compassionate ground. And your lordship, if I may please, another judgment passed by this honorable High Court.
On what? On what
Limited to
proposition?
one person. Second last page, your lordship, paragraph 18. On the left side. 18. Miss such and such has, however, vehemently objected to the submission made by the learned counsel for the petitioner by contending that in the present case, there is no agreement whatsoever, written or oral, on the basis of which the claim of the lordship. I'll take you to the relevant portion, lordship. 5 lines from the bottom, even. And therefore, even assuming
Is even assuming
that the petitioner has a right to be appointed against the land donated, the rights of the petitioner, if any, is barred under 3C, that is limited to 1% of the said notification, which provides that employment to landowner, if permitted, shall be limited to 1%, first appointed, and does not entitle his descendants for further employment on his retirement from service. Paragraph 19, same page, that last line, second last. Even otherwise, the notification dated such and such clearly provides that the appointment of landowner shall be limited to only 1% and not more, Your Lordship. Your Lordship, on aggrieved person, Your Lordship. Paragraph 7, Your Lordship, in this present case, only by making a mere statement that there was an oral agreement, Your Lordship, there's nothing.
Para?
Paragraph 7, Your Lordship. Your Lordship has got it.
Yes.
In the present case, there is nothing to show that the landowner or donor had entered into any oral or written agreement with the government, which incorporated a condition to appoint the landowner or his descendants to a grade 4 post in lieu of the land donated for construction of the office of the such and such. In light of the above, this court is of the view that no legal or fundamental right of the petitioner has been violated. Accordingly, the petitioner cannot be said to be an aggrieved person, Your Lordship. Para 9, Your Lordship. Lordship has got it. A perusal of the above notification such and such clearly state that unless there is an agreement providing for giving employment to a government post in exchange for the donated land, the question of considering a person for appointment to a government post on the basis of a landowner, donor, or descendants of the land owner, donor does not arise. The division bench in judgment and orders such and such had also held in para 13 that no right flows to the landowner who have donated land free from all encumbrance and where there is no provision for giving appointment on the basis of land ownership, Your Lordship. So division bench is also upheld, Your Lordship. Lordship on locus, Your Lordship. For SCC 469. Paragraph 9. Aggrieved person and locus.
Para? 9.
9.
Yes.
Person aggrieved. It is a settled law proposition that a stranger cannot be permitted to meddle in any proceedings unless he satisfies the authority court that he falls within the category of aggrieved persons. Only a person who has suffered or suffers from legal injury can challenge the action, order, etc. in a court of law. The writ petition under such and such of the Constitution is maintainable either for the purpose of enforcing a statutory or legal right, or when there is a complaint by the appellant that there has been a breach of statutory duty on the part of the authorities. These are Lordship principles, Your Lordship.
Yes, principles.
And Your Lordship, I'll place one last citation, Lordship, passed by this honorable court on separation of facts and unclean hands, Lordship.
Separation of X.
Lordship. Paragraph 22, page number 10. A matter of concern in the case is the matter in which the petitioner has conducted himself in filing the present writ petition. It is seen from the pleadings that the petitioner, for reason best known, had deliberately not disclosed that the landowners who had been appointed to different posts as such and such, which also includes the petitioner's own uncle, like the present case, Your Lordship, the younger brother of the petitioner's father. It is therefore clearly discernible that there is non-disclosure of material facts, and such non-disclosure in the considered opinion of this court could have only been for the reason that it could have tainted or adversely clouded the claim of the petitioner to be appointed to the post on land ownership basis. The petitioner has therefore not come before this court with clean hands and is guilty of suppressing material facts, which otherwise was relevant for a proper and judicious adjudication of the case. The petitioner is therefore not entitled to any relief either in law or in equity, and his claim for appointment to the post in question on land ownership basis is also rejected on this ground. And paragraph 223 are the principles of the Supreme Court, Your Lordship. Therefore, Lordship, in respectful submission and to sum up, Your Lordship, as stated earlier, Your Lordship, the respondent number 6 have applied on compassionate ground, and the respondent authority has followed all the procedure. And I was appointed under the scheme of compassionate appointment, which I have. So therefore, the petitioner has no prima facie case, Your Lordship, and since the petitioner is not claiming appointment on the ground of compassion, on the basis of compassionate ground, the petitioner has no locus to question my appointment, Your Lordship. That's all, Your Honor.
Your Lordship,
Any reply?
if I may, I have only 3 submissions to be made. Firstly, Your Lordship, now the parties have stated that the petitioners, they have not availed any facilities, which means that facilities means it includes many things. So in their additional affidavit signed and sworn by the state respondents, they have clearly stated that the Director of School Education is silent on the appointment of any member from the family of the petitioner to the government service on land ownership basis. That's one point. Secondly, suppose a post may be advertised by the department, and then I being a landowner, I may apply for the post, I may get through the exam and then get passed. Does it, if I get passed, can I say that I get that appointment through land ownership basis? No. Similar like Mong Tushi. The advertise the post, I applied, I being a landowner, so I can also apply. And then if I get through, the department cannot see that I got appointment through land ownership
I
basis.
don't think it was advertised.
Yes, Lordship, that's why. In short, Mr. Mong Tushi, it was just an illegal appointment in short. Because in the appointment order, it clearly says that it's only for ad hoc basis. Secondly, I cannot claim for recoloration without routing through interview board. And then accordingly, I was through routing through interview board only I was recolorized. And then even in the, Your Lordship also pointed out that query in that early submission, that is in the early days, they used to issue to appointment order like that. But in extra one, it's clear written there, direct appointment should be made against the appointing, made by the appointing authorities from the landowners. Direct appointment, Lordship. And then despite having this clear decision, again, they have sent me for verification. And the verification also, they have said that, yes, I have not availed any facilities. And then by regarding that facilities, their affidavit clearly says that, and the department is silent on appointment on land ownership basis. They cannot see that I'm appointed, the landowners have been given appointment on ownership basis. And then thirdly, regarding the private 6 respondent appointment, that post was not reserved for landowners or compassionate or whatever, grade 4. But there are certain criteria in a percentage. So I applied for land ownership. Yes, they have also given appointment. I'm not, the petitioner is not saying that he is not eligible for compassionate appointment. He is eligible, but there are certain criteria rules which was framed under in lines with the Constitution of India. Was it followed?
But can you challenge? that
Yes,
decision?
Lordship. Why? Because after the post was vacated,
How are you aggrieved?
after the post was vacated, I applied for the said post. And then he also applied. Yes, no problem for that. But what does the provision say? What does the scheme say? That's the only point, Lordship.
My Lord,
Yes, yes.
the petitioner is relying heavily on the annexure 1 direct appointment,
That direct
is
appointment
backdated 1991.
notification.
1991, already superseded by 2018 notification. That may be considered.
That one is 91, huh?
91 if I'm not wrong. 91 is more.
5/8/1991.
21.
1991, it is already superseded by the new OMU, my lord. So it has no relevance.
I think my lady has already taken note of it, but state is, as per the last additional affidavit, state is not silent as far as appointment of the family members of the petitioners on landowner basis.
Yes, yes.
We are not
State-
silent.
State has said that he is already, that other person is already appointed.
Yes, already appointed.
Heard learned counsel for the petitioner, Shri S. Walling, Gomas, N. Angami, Angami,
Yeah.
government advocate, and I. Jamir for the private respondent number 6. Disposed, petition is disposed. I'll pass order in the
Yes.
chamber.
Obliged.
Chamber disposal. Okay, just send it to the chamber.
May I please,
Yes.
Lordship? Lordship, I seek your indulgence here. Lordship, I beg to mention, hearing item number 33.
33.
Yes, my lord. Can this matter be
Yes.
listed, fixed on 2nd of June, Lordship?
2nd of June. Okay, 33. On the prayer of the learned counsel.
Petitioner.
Is the matter on 2nd June for hearing. Learned additional AG, which Shukri is present.
Much obliged, Lordship.
I think your lordship is holding a brief, which is very heavy,
Yes.
but it will be more heavier,
Looks like that.
which is more heavier now. But of course, on the next date, it will be more heavier because we have Xerox 1,000,
All
12,000
documents.
copies, because 12,000 is a pen drive which is given by the other side in the trial court. So because when initially the case was filed, I told your lordship that it was based only on the law points.
Yes.
When it was entrusted to me, I thought that there is nothing to show before the court to just whether any case has been made out. So now what has happened that after getting the pen drive, about the copies, about 11,000 copies which they have relied in the complaint which they have relied. So this is nothing. Your lordship will be burdened with more heavier, this maybe a trunk, 2 trunks may be here. I'll not trouble with your lordship with this 2 trunks because I think your lordship is sitting the last week, I
Today
think,
is the
last week. So I think they have got a right to reply also in this case, but
You have
not
received-
much.
Yes, your lordship, in the main writ petitions, we have already replied. However, today we came to know that they are, after filing our reply, today we came to know that they have filed one additional affidavit.
Yes, yes.
So, Your Honor, naturally, we need some.
I just pray because I don't have
Yes.
the copy of the reply which they have filed. Because
Yep.
I don't know, my lord, this is a money laundering case. Because the predicate offense, because money laundering case always is initiated on the basis of a predicate offense. Predicate offense, we say Kohima Cyber PS case number 3 of 2021.
Acha.
This is the original, because
Mm.
any criminal activity which flows from the predicate offense, only that proceeds of crime is linked with the PMLA case, ED case. But what I have
Like
seen,
NIA cases. then
yes,
it
yes,
stems from there.
that has to be connected with the criminal activity in respect of the proceeds of crime. Now that I don't know, because that was initially when I was representing this case, that proceeds of crime also was put to challenge. Because till today, it is this investigation of the predicate offense is inconclusive. They could not name this person as an FIR. I have not come across, with great respect to the ED, 295 accused. I have not come, 295 accused. I think last for 10 years or so, it cannot be 295. And your lordship will kindly see, it is in respect of your, just I'm putting it for your lordship, that what is the nature of the case. In Nagaland, there are a lawyer from Delhi has made an email to the cyber PS case, to the SP, along with 2 lawyers from Dimapur, that there is a particular fraud which has taken place in Kohima, around Kohima. There is an app. Now your lordship knows it's very delicate. All these phone calls come, we do not pick up. Your lordship has seen, there is a lot of
Yes.
warnings are there. So there is an app which is called HPZ token app. There's a website. So that website, this fraudster, they said, this is the website. In this website, what you can do it, you can put some money in that website and you will get double of the amount if you invest. So the investor, they thought that, yes, let us invest this money. They invested this money. 30 lakhs something they invested from 30 bank account. And ultimately, they received also some amount, 13 lakhs was not received by them. Now, after 2-3 months, this website, they tried to contact those fraudster who was operating, and that website was closed. They are not receiving the call. So in this manner, a case was registered, cyber PS case, on the basis of a lawyer from Delhi. He made an email to along with 2 lawyers from Dimapur. They registered this case. Your lordship, till today, my name has not been reflected. Directly or indirectly, your lordship knows under section 4, you can be involved. Now, one platform, they said in this complaint, one payment platform, suppose Google Pay. My lord, I can use a Google Pay, your lordship can use a Google Pay, a fraudster also can use a Google Pay. Now that fraudster was using that one payment platform, which this petitioner was using also the payment platform. Now they are linking that you have used, they have used, so I link with this case. This is what they have done it in the present case. So I think that
But still, the preliminary stage, isn't it?
Yes, Your Honor.
Investigation.
Yes, Your Honor.
investigation is
some-
over, complaint has been filed. Investigation is over.
Over.
Complaint has been filed, which is registered in money laundering case. 1 of 2024 has been registered before Dimapur court. So we have come for questioning of that entire complaint. They have already raised, investigation is completed. Their allegation that you don't cooperate. Their allegation you don't cooperate. Your man is sitting in Dubai. That's their. But now, when it comes to the court, my lord, your lordship knows there is no investigation is out of hand because it has gone. Today also, I am telling your lordship that I'll advise my client to cooperate with them. Absolutely, there is no problem. But they should not take any coercive measure. That's the whole difficulty. Now the complaint is, now the proceeding has started, initiated. So let them, my lord, they have to give a reply. In
Your
this
Lordship,
case,
investigation is not yet complete, Your Lordship, although we have filed the PC, prosecution complaint. However, as per the provisions of the PMLA, after filing the PC also, the investigation is continued. We have issued 11 summons to him to appear before us. Even the Honorable High Court in the previous rate has directed to cooperate the investigation officer of ED, but he have never appeared. Thereafter, your lordship, the special court has issued summons, non-bailable warrant, and in the instant case, he has been declared FEO, a fugitive economic offender. And
Which has
red
been-
corner notice is also issued against him, Your Honor. Anyway, that is the.
No.
what is the-
I'll tell your lordship. He should not give an impression something he doesn't know. Fugitive economic offender has been stayed by this High Court. It has been stayed after hearing the ED. It has been stayed.
That one has been.
Your
stayed.
lordship has known that 2 orders has been stayed. Now, I have not come across, once you file a complaint, where is the scope of an investigation? Further investigation under CRPC is 173(8). Trial is going on. Full-fledged trial is going on. How can my learned friend that investigation is not completed?
Your lordship, we will clarify the court's.
It's okay,
result.
fine.
Sir, Now, your lordship, since they have filed the additional affidavit today, so let me go through this.
You have received a copy.
I have received, your lordship.
So what I suggest, my lord, subject to convenience of lordship, my learned friend. So it can be fixed somewhere on 29th. So they get sufficient time, 29th. 29th, so today is.
Today is
16th,
16th.
you get 2 weeks. Because this is
So
a
2
small
weeks.
additional affidavit.
2 weeks.
Yes.
Your lordship, we have to obtain the instruction from the.
Let them,
judge.
because my urgency is also there. This
At
is always, I'm.
3 weeks time. maybe.
No, my lord, 2 weeks, that will come on 29. If there is some inconvenience, you make a prayer.
29 or 30? 30?
No,
30?
Friday, 38 is a Friday, last day of the court. So 29, let it be on Thursday, ma'am.
29th.
29,
Okay, Lordship.
29.
It's from Guwahati only, I think. You have to get the
Guwahati,
instructions.
but our office is Calcutta also. Because for the vetting purpose, we have to send the
Oh,
to
take
Calcutta.
Kolkata, not Guwahati.
Guwahati is the
No, but
joint
these-
director.
these days, yeah, everything is done online, so.
Your
There
Lordship,
is
no
highly,
issue.
so let it be on
Learned
29th.
Counsel, Learned PP, Special PP, YP Gupta, for the respondents has stated that he has received a copy of the additional affidavit filed by the petitioner only today. Stop. And accordingly, he prays for some time to file a reply. To receive instructions and to file a reply if so advised. Stop. Accordingly, list the matter on 29th of May, 2025, on which date the respondents shall file their affidavit.
Prayer for interim order
reply,
will be,
and the prayer for interim order will be also considered on the next date.
I'm deeply obliged, ma'am. I copied it. So affidavit and reply.
Just
You
take
have
it.
filed.
Earlier, I've already submitted.
No, I have not received.
Hearing.
I'm deeply obliged.
Oblige your Lordship.
Orders? 30. Nine. Ever